Hello, welcome to our presentation about the GDPR, the General Data Protection Regulation. We will first of all explain to you what GDPR means, which terminology it uses. Afterwards, we will explain the rights of a data subject, the scope, where it applies, and which fines you need to pay if you don't play by the rules, in which cases you're allowed to process the data, what GDPR has to do with cookies, what its impacts are on the web, on market concentration, and last but not least on cloud computing. So what is GDPR actually? So in the 1950s European Convention on Human Rights, it is stated that everyone has the right to respect for his private and family life, his home and his correspondence. And with the ever-growing internet in the recent years, the control of your personal data has become ever more difficult. And for example, in 2011, Google had been sued by a user for scanning her emails. And therefore, the aim of the GDPR is to protect your personal data and to harmonize data protection rules within the EU, because data is traveling all around borders. But the GDPR does not only apply to online services, but also to the offline world. So this is a very important point. The regulation went into force in 2018, and it contains 99 articles altogether. So, terminology. Data subject is the individual whose data is processed, for example, a customer. Personal data means the data that identifies someone directly or indirectly, for example, names or email addresses. A data controller is the one who is in charge of the processing of the personal data, and processing means just the handling of the data, collecting, organization, structuring, basically everything that has to do with handling the data. And the data processor is a third party that processes personal data on behalf of the data controller. Very important point now, what are your rights stated in the GDPR? The first one is the right to be informed. This means you need to be informed about the collection and use of your personal data in a concise, transparent, intelligible, easy accessible form, and the data controller needs to use clear and plain language. The second right is the right of access. So you can request a copy of any of your personal data that has been processed. And the third one is the right to rectification. So if there is an error in the data, then you have the right that it is being corrected. The third point is erasure. So if you don't want your data to be stored anymore, then you have the right that it is deleted. So the fifth point is restriction of processing. And for example, in case there is an error in your data, you have the right to stop the processing until the data is corrected. Sixth point is portability. So you have the right to transmit the data to another data controller. For example, if you are a patient in the Belgian clinic, you have the right to transmit your data to a German clinic in a machine-readable form. Seventh point is the right to object. For example, when your data is processed for direct marketing purposes, you can just object that. And last but not least, the rights in relation to automated decision-making and profiling. So you have the right not being subject to decision-making solely based on automated processing. An example would be if you apply for a bank loan online, sometimes algorithms tell you if you get it or not and what the interest will be. And then you have the right to contest that and demand a review by a person if you are not confident about that. So the scope and the fines. So where does the GDPR actually apply? It applies to everyone who processes personal data of you citizens or residents, who offers goods and services to them, and it applies even if you are not located within the EU. So if you are located in the United States, you cannot just say regulatory, I don't care. If you provide services to EU citizens, then you still have to play by the rules. And the fines for violating the GDPR are very high. So either 20 million or 4% of global revenue at maximum. And we have 2 examples of companies who did not play by the rules. So Google, for example, disclosed their data processing too vaguely and had to pay 50 million euros. And H&M in Germany monitored some of its employees, stored private information about their vacation and religion and stuff like that, and they had to pay 35 million euros, for example. So when are you actually allowed to process the data so we don't want to pay this huge amount of money? You can process the data under the following 6 conditions. The first one is unambiguous consent. So for example, if you opt into marketing cookies or marketing email list. Second one is when you enter into a contract. The EU, for example, uses the example of when you need to do a background check before leasing a property. Third one is to comply with the legal obligation. So if you receive an invitation to speak in front of a court, for example. The fourth one is to save somebody's lives. The EU says, when this one applies, so no example is given here. Fifth is to perform a task in public interest. The EU uses the example of a private garbage collection company. I was also thinking about the mail service, for example. They need to have your address. And last but not least is legitimate interest. This is obviously very vague. The EU cites here fraud protection as an example, or fraud prevention as an example. And I wasn't completely sure what that could mean, but I was thinking about when you know someone who is planning a robbery, then you might be allowed to give his or her name to the police. But don't count on me for legal advice here. When are you allowed to transfer data to third parties? So you are allowed if you adhere to the rules I displayed before, but we wanted to stress that in particular, selling user data to third parties requires provision of consent in most of the cases, according to the EU. And we have one example of a violation. This is the company Bounty. It sells pregnancy and parenting packages and stuff like that, and it shared personal data like baby photos and stuff with 39 organizations without informing the users, and they had to pay a fine of £400,000, but they stopped this procedure right before the GDPR went into force, and under the GDPR they would have to pay £17 million, so much more. When are you allowed to transfer data to third countries? This is also important as data is like traveling around the globe, but the GDPR travels with the data, so you need to continue to apply the GDPR regardless of where the data is transferred. And there is the so-called adequacy decisions. If you transfer data to those countries, then you just have to adhere to the rules I explained to you in the slides before, but there are no additional requirements. And this applies to Andorra, Argentina, Canada, and a bunch of countries which we cited here. If there's no adequacy decision by the European Commission, then you can still process or transfer data to third countries, but you need to provide additional safeguards. And there is one example, like the standard contractual clauses approved by the European Commission. When you adhere to them, then you can transfer data to other third countries. Next point, cookies in the GDPR. Cookies are actually part of the e-privacy directive, which supplements the GDPR, so they are not directly regulated by GDPR, but as they are personal data in many cases, they are still subject to GDPR. Cookies are small text files placed by websites on your device while you're browsing, and they are stored by your browser in most cases. And since the GDPR, there has been an increase in the amount of cookie consent banners, which you might know. And there are different types of cookies. Like, for example, duration cookies. These can be session cookies, which are temporary and expire when you close your browser. But there are also persistent cookies, which remain on your hard drive. And provenance, there is the difference between first party and third party. So first party cookies are cookies by the website you are visiting. Third party cookies are placed by a third party, mainly for analyzing your behavior on a website or for advertising purposes. Then different types of purpose cookies. There are strictly necessary cookies. They are necessary for the functioning of the website. So yeah, they just need to be there. There are in general first-party cookies. Then there are preference cookies. They remember choices you made in the past, like the language you choose on the website. Then there are statistic cookies. These are cookies about or that store how you use the website. They are anonymized and they aim to improve the website, and they are mostly third-party cookies. And last but not least, there are marketing cookies, which track your online activity while you are browsing, and they are also mostly third-party cookies, and they are persistent in general. So that's it from my part, and now Rafika will explain to you the impact of GDPR on the web.
And now I will talk about the article called GDPR and its impacts on the web. This article was published by Anderson and von Zek in 2020. But what is this article about? Paper, first of all, introduces the rules of GDPR and basic principles of data collection and processing. But more importantly, discuss changes that have occurred on the web after the enforcement of GDPR. As a quick summary, what was the impact according to authors? Well, less cookies are being collected, and users are now requested to give consent more often than before law enforcement, and they have the ability to inform themselves about data processing. However, according to Anderson and von Zek, changes through the GDPR do not actually create more transparency on the web because policies are too long and complex. Now let's look at impact of GDPR specifically on cookies. We all already know what a cookie is. It's information about a natural person that's generated by website and stored on computer. They track users' activity and remember information. For example, information about our shopping history. Well, what happened after GDPR? There has been an increase in the amount of cookie consent banners. Companies had to create consent forms in order to be allowed to further collect individuals' data, and then they had to adjust the way they process data. This, of course, mostly applies to consumers from Europe. And however, GDPR even has an impact on users outside the EU. So when comparing the results from 2016 to the results from 2018, US consumers actually profit from a reduction of up to 46.7% of the amount of cookies collected. So the amount of cookies collected decreased significantly. And therefore, the new cookie policies have, in theory at least, impacted users' privacy in a positive way all around the world. However, users are found to be disturbed by the frequent occurrence of disclaimers because now they are obliged to give their consent on most websites, otherwise they are not able to access the page. And they also seem to have more privacy concerns because now they are aware that their activities are being monitored and their data is being used. So looking at this from a practical point of view, only very few users are actually willing to click on banner and read through how the cookies are being used. So this doesn't really add to a higher transparency. If users, for example, are confronted with an enormous amount of words that they are not even willing to read, people are not empowered and process doesn't actually become more transparent. Now let's look at what is impact of GDPR on privacy policy. First of all, many companies had to adapt their privacy policies in order to be compliant with the requirements of new regulation. And the ones that didn't have a privacy policy had to create one. If they already had an existing policy, they had to renew it based on new regulations. But what is worth to mention is that having a GDPR compliant privacy policy doesn't necessarily mean that it's transparent to a user. So the length and difficulty to understand provided information also play an important role. On screen we can see a figure. Well, what does this figure mean? It considers reading time, how much time is required to read privacy policy of different companies, and it considers it looks at reading time before and after the application of GDPR. And according to the figure, we can see only Facebook and Reddit actually simplified their privacy policies. So reading time required for this privacy notes actually decreased. However, all other companies made their privacy policies lengthier and more complicated, and one of them is actually Wikipedia. Reading time required for a privacy policy of which dramatically increased. Now, GDPR hasn't succeeded in increasing trust in digital economy. More than 80% of US citizens have the feeling that they don't actually have control over the information they reveal on the internet. What is problem? Problem possibly arises due to the points we already discussed. For example, privacy policy, which is too much complicated, or number of cookies. Even though 2/3 of Europeans are aware of the existence of GDPR, there doesn't seem to be a strong relationship between awareness of data protection regulations and the actual feeling of safety. A reason might be GDPR is quite complicated to understand. Now let's look at impact of GDPR on third-party presence. We know that in business environment there is an interdependency between websites. But what is meant by interdependency? An interdependency exists if one website uses services of another web page in form of third-party presence. For example, Google Analytics. Google Analytics is a service that tracks website activities, for example, session duration. And for a person's privacy, it means another entity has access to their activities. And thus, it's interesting to look at to determine if the third-party presence has decreased since enforcement of the new regulation. So what we have on the screen is a figure which compares pre- and post-May 25's average numbers of unique third parties for countries listed as change in percent. We can see Austria shows the biggest change with a decline of 46.79%, whereas in France, for example, average number of unique third parties actually grew by 4.83%. Well, it shows a decline in most countries and in the total number of third parties. What is impact of GDPR on newsletters and data vendors? So how GDPR affects newsletters? Well, data subjects subscribe to a newsletter, and before the enforcement of GDPR, already a number of people subscribe to this kind of letters. The organization must have collected data in a lawful way. So after the application of new regulation, organizations had to prove that they have users' consent and have lawful reason for processing data so that they can continue sending messages to the data subject. So GDPR specifies what consent is. It must be freely given, specific, informative, and unambiguous. Well, if this is not the case, their personal data has to be deleted. So companies are forbidden to use personal data for any other reason than specified. Thus, previous to the law, a company could, for example, use contact information for a user that bought an ebook, for example, to send them recurring email campaigns. Now they must add another checkbox where the user must agree that their information can be used for other marketing actions. If this is not agreed upon, no emails or letters can be sent to them. Data vendors. Here we consider companies like Google and Facebook, which provide free usage of their platforms in exchange for user data. But what they do, they track activities like browsing history, likes, and purchases. And there have been numerous scandals in the past concerning data privacy and protection because Google and Facebook then sell data to advertisers so that they can better direct their ads. Well, GDPR regulations influence this business model severely. In general, these companies now have different policies for the countries to which GDPR applies and all other countries. For data collection and processing of Europeans, Euro population, the controller now has to follow the rules that were discussed in this presentation so far. For example, they have to get consent from data subject, prove the lawfulness of storing data, maintaining data, and so on. Now, GDPR led to increased market concentration. A market for web technologies actually became more concentrated after the GDPR. We can also see from the picture that Google sticks out as the clear winner. Market shares of all other firms remained either unchanged or decreased. In this picture, we see largest, let's say, companies, and except for Google, market share of all others actually decreased. But Google gained most in the analytics market and advertising market, and these two were the strongest markets before the GDPR. Well, what can be explanation for this? Why Google stick out as the winner? Well, Google and other big tech companies had significant resources dedicated to compliance, so it was easier for them to follow new regulation. Also, Google may have used its dominant position to encourage publishers to reduce the number of trackers on their sites, thus the number of edtech vendors. GDPR and its impact on cloud computing. In general, under GDPR, personal data may not be stored longer than needed. Therefore, retention periods must be implemented, and companies have to be able to delete data effectively when those retention periods expire. Well, what is problem here? Difficulty appears when, for example, data is stored on multiple locations under multiple jurisdictions by cloud service providers, because they are now subject to a number of jurisdictions, and they each may have different retention requirements. Also, another challenge is related to the deletion of data. To delete data, because to delete data completely, backups must be taken into consideration, and therefore it's important to have a clear overview of how backups are secured and retention is managed by cloud service providers. Breaching response and coordination. Well, now companies had to include breach notification obligations and protocols into their data processing agreements. The contract has to define a breach event and describe a procedure for the controller. That was all we wanted to tell about GDPR, what this regulation is about, and how it affects web and cloud service providers in total. Thank you for your attention.